Hey there, and welcome to This Explainer. Look, if you're tuning in right now, chances are you're juggling a full-time job, managing a household, and somehow finding the hours to study for a brand new law degree from home. I know exactly how demanding that is. It's a lot. And that's exactly why we put this explainer together specifically for you. We're going to cut right through that dense academic fog and give you a high-level, super practical guide to one of the most absolutely crucial subjects in your new legal journey, UK contract law.
Right off the bat, I want you to really think about something. What actually separates a casual promise you make to a friend from a legally binding contract that a judge will actually enforce in a court of law? I mean, it sounds like a simple question, right? But the legal machinery working behind the scenes to answer it is just immense. So our goal today is to give you the mental framework to tackle this question like a seasoned law student.
Okay, let's dive into our roadmap for today. We're going to cover the law degree roadmap, defining civil liability, forming the agreement, common law versus statute, and finally, the modern contract challenge.
Section 1. The Law Degree Roadmap.
Before we get into the real nitty-gritty of things like offer and acceptance, we need to understand the macro context. Like, where exactly does this subject sit within the overall architecture of your studies? Well, whether you're looking at UCL, the London School of Economics, or Cambridge, you'll notice a very clear pattern. Contract law is an unavoidable, absolute core pillar of Year 1 foundational studies. It sits right alongside tort law, public or constitutional law, and criminal law. And why is that? Because the general principles of contract formation, terms, and discharge, they apply to almost every single commercial and private interaction in our society. Mastering this stuff right now, it literally validates your entire foundation for Year 2 and 3 modules, like commercial law or company law.
Moving right along to Section 2, defining civil liability.
So, we know it's super important academically, but let's zoom in a bit to see exactly how contract law fits into the wider ecosystem. When we talk about civil law, as opposed to, say, criminal law, we're generally looking at 3 distinct buckets: contract, tort, and restitution. They all stem from that central idea of civil liability. Now, restitution is mostly about preventing unjust enrichment, but as a first-year student, your primary focus is really going to be navigating the boundaries between contract and tort.
And the absolutely vital distinction between those two is this. Contract law is entirely based on the facilitation and enforcement of a voluntary exchange transaction. You actively choose to enter into it. Tort law, on the other hand, is about the imposition of standards of behavior. Think of the famous 1932 case of Donahue v. Stevenson, the one with the really unfortunate decomposing snail in a ginger beer bottle. In that situation, the manufacturer had a state-imposed duty of care to the consumer, completely regardless of whether any contract existed. So, simply put, contract is voluntary, tort is involuntary.
Section 3. Forming the agreement.
Now that we've sort of mapped the territory, let's strip away all that complex legalese and look at the actual anatomy of how a valid contract is formed under English law. If you take the abstract idea of an agreement and turn it into a practical, digestible checklist, the courts are basically looking for 3 steps. First up, an offer by one party. Second, an unequivocal acceptance by the other party. And third, an intention to create legal relations. Crucially, the courts use an objective test here. They don't try to mind read to see if the parties subjectively agreed in their heads. Instead, they look at what the parties actually said and did and ask, well, what would a reasonable person conclude?
But here is where English law gets uniquely fascinating. Even if you have an offer, an acceptance, and the full intention to be legally bound, the law still doesn't enforce all agreements. Nope, it requires a very specific hallmark, a badge of enforceability, if you will, to elevate a simple, everyday promise into a binding contract.
And that badge of enforceability is called consideration. This is a uniquely English contract law concept, and honestly, it frequently trips up beginners, so let's lock it in right now. Consideration simply means there has to be mutuality in the agreement. It's the price paid for the promise. Both parties must bring something of value to the table, or they have to suffer a legal detriment for that promise to be enforceable. You can't just enforce a promise to receive a free gift, right? It's a two-way street. You have to have given something in return.
Section 4. Common law versus statute. Let's see how this all operates in the real world. A massive part of your degree is going to be exploring the tension between historical, judge-made common law and modern legislative controls. And there's no better example than the wonderfully absurd 1893 case of Carlyle v. Carbolic Smokeball Company.
Basically, a company puts an advert in the paper offering £100 to anyone who uses their smoke ball and still catches the flu. Well, Mrs. Carlo did just that. The court ruled this was a unilateral contract, an offer made to the world at large, which she accepted simply through her conduct. Her consideration, her badge of enforceability, was the legal detriment and absolute inconvenience of having to use that smoke ball 3 times a day for 2 weeks, exactly as instructed. It's just a perfect classic showcase of the common law freedom of contract.
But you have to contrast that historic sort of Wild West freedom with the reality of modern mass commerce. Enter the Unfair Contract Terms Act 1977. This statute aggressively steps in to protect consumers and weaker parties from unfair commercial power. For instance, Section 2.1 places a total, absolute ban on a business trying to write a contract that excludes their liability if their negligence causes death or personal injury. You simply cannot contract your way out of it, period. As you study, you'll find yourself constantly weighing this balance, the freedom to contract under the old common law versus these statutory interventions designed for fairness.
Finally, Section 5, the Modern Contract Challenge.
Look, to really excel and crush your academic essays, you need to go way beyond just memorizing rules. You need to start questioning the frameworks themselves. For a long time, English law has operated on classical contract theory. This basically assumes contracts are these discrete, one-off transactions between parties who have equal bargaining power, kind of like 2 merchants haggling over a horse in the 19th century. But critics argue this is a totally rigid, historical paradigm. Today, we live in a messy world of relational transactions. These are long-term, continuing relationships, often with vastly unequal power dynamics. Think about it. It's like you checking an I agree box on a massive tech platform's terms of service without even reading it. Not exactly equal footing, is it?
And that leaves us with this final provocative thought. As you dive into your textbooks late at night after a long day of work, keep asking yourself this: is the law of contract built on 19th century common law ideals really still fit to regulate our modern, fast-paced, platform-driven world, or are we just trying to force a square peg into a round hole? Keep that critical perspective alive, and I promise you, you're going to do fantastic in your degree. Thank you so much for joining me for this explainer, and hey, happy studying.